Hey guys, can y'all hear me? All right, hot off the press. Excuse the morning mess, but you know how it is when you're trying to get ready for stuff and you just got to get something online here. Decisions made from today's hearing to set the stage in Delphi trial by Russ McQuaid. Carroll County prosecutor Nicholas McLellan has told the defense and the court what he will and will not agree to surrender to the attorneys representing accused Delphi killer Richard Allen. Remember, any and all people accused are innocent until proven guilty in a court of law. So everything I'm saying here is from the news, and if there's any assumptions, it's on them. I'm just reading it from the news. Special Judge Fran Gull will hold a hearing in Carroll County Circuit Court Friday to listen to arguments regarding a change of venue, a permanent gag order, and a defense motion that lists 29 specific pieces of evidence the attorneys claim they need to defend their client against charges that he killed Libby German, 14, and Abby Williams, 13, near the Monone High Bridge on February 13th, 2017. I think the defense is doing the right thing and making a list of everything that they haven't been given, so it's in the record so everyone from here on out can see everything that they have not been given so far, said Attorney John Tompkins, who is not connected to the case. You have to see everything. You have to see the entire investigative file. You have to see every interview that was ever done. You have to see every lead, every other suspect, what their sources of information were, so you could see if it was trustworthy and reliable. You have to see the applications for search warrants to see if they were based on hearsay. Noted Indianapolis defense attorney Bob Hammery, also not connected to the case, said the search warrant evidence may be key to quashing any items investigators claim they took from Allen's house in October. I'd want the search warrant and the affidavit for the search warrant to find out if there was going to his house, that it's legally supportable. That's the first thing I'd want to find out, he said. The prosecutor, if they're going to file charges, then file the evidence. Make it in the discovery. Get it to the defense counsel and let the public see what the evidence is in this case. It just can't rely on the opinion of the prosecutor. I have to agree with that, but if it's going to jeopardize the case for these two girls and give out information that may lead or give hint to those other people possibly involved in the murder, then keep it closed until trial. In his response to the defense motion, McLellan readily agreed to or provided clarification to 18 requests for information regarding the identity of witnesses, statements, case reports, the search warrant, evidence favorable to the defendant, and other items that were typically covered by Indiana trial rules. McLellan represented that there was no grand jury called to hear this case. The prosecutor objected to several other defense requests. McLellan said he would not provide a statement attesting to exculpatory evidence favorable to Allen, nor a summary of the state's opinion on statements made by Allen or witnesses, writing, "The defense seems to be asking the state to do their work for them and formulate a defense for them. The information about ongoing litigation by a retired Carroll County Sheriff's deputy," say that 10 times fast, claiming he was demoted and targeted for retaliation because he offered an investigative alternative during the early days of the case that was rejected by Sheriff Toby Leesenby. During a hearing in November, McLellan shocked the courtroom by announcing that investigators believe Allen did not act alone in allegedly committing the murders, yet no other names have been directly connected to the murders. The prosecutor has already said that there's other suspects, said Hammerly. There's no evidence in there that there's any other suspects. So the fact of the matter is, if the prosecutor is going public and saying that, get on there from discovery and reveal the basis of that. McLellan did respond affirmatively that the state would comply with a defense motion requesting a statement as to whether the defendant or any other person who participated in the alleged crime was acting directly or indirectly at the investigation or on behalf of the state of Indiana. Child pornography and child solicitation charges have been filed against Keegan Klein, a Peru man who is accused of communicating with Libby on social media the night before the murders and arranged to meet her on the bridge that day. Klein's attorney said his client was cooperating with investigators, though the extent of the content of the assistance have never been revealed. Judge Gold will also hear arguments as to changing the location of the trial. Imagine the jurors from that county if they had to go home and feel constrained and compelled to find him guilty, or everyone else in the county, once a not guilty verdict was returned, would know that they were the 12 people who found him not guilty, but would not know the full extent of the evidence that justified the not guilty, said Tompkins. That's confusing and a tongue twister. Judge Gold placed a temporary gag order in effect following a 3-page defense press release arguing for his client's innocence at the start of December. The court will hear debate Friday on whether to make that order permanent. I would think that she would keep it in place, said Hammerly. There's no harm to having that gag order on both sides for commenting on, etc. The judge has said she will take Friday's arguments under advisement in order to issue final decisions in the weeks and months to come. There's so much information to deal with, there's so much volume of material to deal with, and the rulings she makes now are going to last for the life of this case, said Tompkins. The defense will also go behind closed doors with the judge to seek funding for an investigator to work on Allen's case. Yeah, y'all get to pay for that if it happens. So heartfelt, I am so sorry, apology for that. But we'll see what else is coming. Have a great day. Okay.